Okay, we'll go ahead and get started so we can stay somewhat on time. My name's Steve Buck. I'm a partner at the firm, and I practice primarily in the areas of employment, labor, and business litigation. I'm going to talk today about handling workplace investigations. And while on its face it sounds pretty straightforward and simple, there's some guidelines and rules to look out for. I mean, primarily what you want to do is if you have an incident that you think needs to be handled or discussed, you need to act quickly, you need to plan for that investigation, you need to act impartially throughout the investigation, and you do need to reach a conclusion, so you take some action. The other thing to keep in mind, and becomes a problem at times, is that investigations are supposed to be what you conduct in order to base your decision on what your findings are. The investigation is not supposed to be a justification or a rationalization for some action that you've already taken. And when that happens, you can cause some problems. And so the question is, why bother with an investigation? Well, primarily because the failure of an employer to conduct an investigation when warranted, or conducting an investigation poorly, can ultimately lead to judgment or liability on the part of the employer. And this is the case in private and public sector employers. And today we're going to talk mainly about public sector employers and issues that are unique to that. But some of the examples I'll give, and the first one I want to talk about is actually a private employer, but the points hold true. And it's a case of Castelluccio versus IBM. And Jim Castelluccio was he began to work for IBM in 1968, and he worked his way up through the ranks, through middle management, and in 2005 he was appointed a vice president of integrated technology, where he supervised over 2,500 employees. Throughout his career, he'd received excellent performance reviews, including from his supervisor when he first took over as the vice president of integrated technology. In 2007, things changed for Mr. Castelluccio. His supervisor retired, and a new supervisor was appointed. It was a younger female supervisor. In the first meeting he had with his new supervisor, she looked at him and said, "Well, how old are you? And you got any plans to retire?" And that kind of dialogue continued as they had meeting after meeting. She was constantly asking him when he wanted to retire and what he planned to do in retirement. As this pattern went on, he finally felt uncomfortable, thought he was maybe being pushed out, and he reported it to Human Resources. At that point, the Human Resources did technically the right thing. They started an investigation, and they said, this will be an open-door investigation. We want everybody to come to us. We want to have a dialogue. But while their investigation was getting underway, things began to happen to Mr. Castelluccio. First, he was transferred to a new position. And in that new position, he was on call 7 days a week, and he started working 7 days a week constantly, month after month, until he realized he was being pushed to quit. And when he wouldn't quit, he was put on the bench. And at IBM, being put on the bench meant you'd completed your assignment, and you were basically kind of put in queue to receive a new assignment. And after 6 months on the bench, he was terminated because they couldn't find a position for him. And during this time, he was getting poor performance reviews from his new supervisor. Well, what does he do? After he gets terminated and let go, he files a lawsuit for age discrimination, and the jury finds, in fact, he was discriminated, and that IBM knew or reasonably should have known that he was terminated based upon his age, and he won $2.5 million in compensatory damages and $1.2 million in attorney's fees, and at that point, he was probably ready to retire. But you say, wait a minute, Steve, IBM conducted an open-door investigation, so how could that possibly be? Well, the judge wouldn't even allow the investigation to go to the jury, because what the judge found is that although said to be an open-door investigation, what IBM actually did was justify its actions. And what they did is they focused on his current job reviews from his current supervisor. And in the report of the investigation, there wasn't even a reference to his version of events, how he'd been benched, how he'd suddenly gotten bad performance reviews, how he was being asked when he was going to retire. So what the judge found is that they purported to conduct an objective open-door investigation, but what they really did is they just justified their own termination of Mr. Castelluccio. The other thing that happened during the investigation is IBM went to Castelluccio, the HR department, several times and said, hey, if you just quit and sign a separation agreement, we'll stop the investigation. And they made it clear to him that he was now the target of the investigation as opposed to the alleged victim of the investigation. Ultimately, the judge concluded that IBM would have been better off handing this off to an independent investigator, somebody outside IBM, in order to have done it properly. So again, the key takeaways: be objective and be impartial. And the Castelluccio case is point positive of that. They were targeting and they were trying to exonerate themselves. They weren't being objective. They weren't listening. They weren't really trying to figure out what, if anything, was happening with his age discrimination claim. Another quick example I want to give you is it was a case called Otto May. The gentleman's name, Otto May, and it was versus Chrysler Corporation. And Otto May worked as a pipe fitter at the Chrysler plant near Rockford, Illinois. Otto was of Cuban descent. He was also Jewish. And he complained of over 70 incidents of racial and religious discrimination, anti-Semitic discrimination between 2002 and 2005. He had threatening notes left at his workspace. He had "Die Jew" sprayed painted in graffiti at his workspace. He had a dead bird left at his workspace dressed in a KKK outfit. Over a period of time, as nothing was getting done, he had his car damaged. He had his tires slashed. He had sugar poured in his gas tank. And he reported these incidents to HR over time. HR, in the very first year when he reported that, they opened an investigation and they assigned an HR person to investigate. And that HR person took the step of interviewing Otto May and doing nothing else. As the second year went on and the harassment ramped up and he started having his property damaged, he called the police and the police got involved. And at that point, Otto May gave the HR folks a list of names. He said, "Here's the folks I think are doing this to me." And he asked if he could have security cameras throughout the plant aimed at his workstation so that they could find who was coming and going and who was doing things. HR, in response, interviewed nobody on his list. Instead, they had 2 general staff meetings with the 60 employees that worked in the area of Otto May, and they went over their anti-discrimination and anti-harassment policies and said, we need to abide by these and we need to treat each other properly. Well, Otto May ultimately, and the other thing was, Chrysler didn't turn the cameras, they didn't adjust those, but they had also been found to have used those cameras to investigate their own claims of vandalism against company property and against theft of company property. So again, the fact that they wouldn't use those to help Otto May played a role in it as well. Otto May finally sued Chrysler for discrimination. He was awarded $709,000 in compensatory damages and $3.5 million in punitive damages based upon the fact that Chrysler took very little effort or no effort to try to intervene and put an end to what was happening to him. So, and during the course of that, Chrysler tried to paint the picture that Otto May was a whiner and a complainer, and he was always complaining, and so they kind of thought he was the boy who cried wolf. And again, I think that points out you've got to be objective, you've got to be impartial. Somebody complains and it's a serious allegation, you need to look at that. If it becomes unfounded, so be it, but don't just assume and take some positive steps towards the investigation. Why conduct one? I think the examples I've given have shown that. I mean, you can avoid mistakes. Castelluccio is the prime example of that. If they actually investigated and looked into that, they would not have terminated him, and they would have avoided liability for a wrongful termination. It allows you to gather the facts that can lead to a proper decision or a proper action. Otto May case is a prompt example of that. They could have, had they done their job, if they investigated, they talked to people, they could have intervened and stopped that behavior. The other thing simply is they tried to portray Otto May as a complainer, but if they actually looked at that, they could have realized he did have grounds for it, and they could have maybe resolved the issue by addressing it and working with him and showing that they cared and that they were on to it, and otherwise handled what was an upset or a disgruntled employee. The other thing that is a factor to consider too is by doing the investigation, you can shut down any claims. If you do get to the point where you need to discipline somebody, frequently I see cases where the person gets disciplined now comes up and say, well, I was disciplined because of my sex or my race or some protected category. But if you've got an investigation, you've done the legwork, gathered the documents, talked to the witnesses, you can shut down any kind of a defense like that by showing what you found and what took place. So when do you conduct an investigation? There's no magic words needed. You don't need somebody to walk into your office as a supervisor or as an employer and say, I want an investigation. You basically look at, is this something that could cause trouble? This is something that could lead to liability. Obviously the general categories are, protected class status. If somebody claims that they're being discriminated against or harassed based on age, sex, race, disability, religion, things of that nature. If you've got health or safety rule violations, that's something that you can or should look at as well. And that would include workplace violence and stalking and things of that nature. There's OSHA regulations now that govern that and put a level of a duty on the employer to address those. Retaliation and whistleblower cases, if you have an employee who says, I'm being treated wrong because I've pointed out prior misconduct, or that the supervisor or the employer is doing something wrong, you need to investigate that. More subtle things you can look at is just a change in a good employee suddenly becomes a bad employee, or morale is down, and you're trying to figure out what's going on there. Or if the supervisor sees some sort of misconduct or hears something in a casual conversation. Again, the easy answer is if an employee does complain or a supervisor does directly see something. The harder is when to decide is if you're hearing something through the rumor mill or just observing sort of a change in attitude. But it is worth at least looking into. And again, the primary reason for doing an investigation is the investigation, if done properly and you reach a conclusion and you intervene in a situation where misconduct is occurring, it can limit the liability of the employer. And that's in the areas of Title VII, which are the protected class status, age, race, sex, religion, things of that nature. There's two Supreme Court cases, Farragher versus the City of Boca Raton and Burlington Industries versus Ellerth. In those cases, the Supreme Court said if you have harassment by a supervisor against an employee, the employer is strictly liable, meaning the employer is liable even if the employer had no knowledge, had no direct fault of their or participation in the harassment. But if it's coworker harassment, the employer is only liable vicariously, which means you have to show the employer was either negligent in discovering the harassment or in failing to put an end to it. So either way, an investigation can help limit the liability. Even if you're strictly liable for supervisor harassment, if you find out about it and put an end to it, you can at least cut off the potential liability and the ongoing nature of it. If it's coworker liability or coworker harassment, and the first thing you do need to do is having a policy in place, anti-harassment, anti-discrimination. That's actually required by law in Illinois under the Illinois Human Rights Act. EEOC requires it too, and part of your policy is you have to have a method by which an employee can complain and process for an investigation of that complaint. But if you have that, you can limit your liability in coworker harassment cases if you can show either, number one, the employee didn't take advantage of that, didn't make a report, didn't make a complaint about harassment when they knew about the process, and you should get a signed receipt of the handbook that shows that process. Or you can show that, hey, once they told us, we conducted an investigation, we found out what was going on, we disciplined the employees who were at fault, we took care of it, we put an end to it. If you can show that, you can limit your liability. The other thing to keep in mind is plaintiffs' lawyers are always adjusting as to the approach that they take, and one of the things they do now is they do attack the investigation. If the underlying claim isn't all that severe, they can maybe make some noise by pointing out that the employer didn't do what it was supposed to do, or didn't take it seriously, or didn't come to the assistance of an employee who was being subjected to any form of harassment. So again, a prompt and thorough and impartial investigation is a key thing to reduce your liability. Who should conduct the investigation once you decide to do one? Well, you should have somebody knowledgeable about your policies, your procedures, about the area of work that's at issue. And if you have a collective bargaining agreement, which certainly in the public sector, most times you're going to have that. Somebody that's knowledgeable about the collective bargaining agreement and the rights and remedies that are set forth in that. You should have somebody also that's experienced with investigations, skilled in interviewing witnesses. The other thing to keep in mind is whoever's doing the investigation, they may very well be a witness, whether it's at a trial at some point down the road or in an administrative hearing before the EEOC or the Department of Human Rights. So pick somebody that's going to make a good witness. You don't want a stiff, or you don't want somebody that comes across poorly. Make sure they're unbiased and they have no relationships with the parties involved if they're going to conduct the investigation. I didn't touch on this a minute ago, but that was a problem in the Otto May case as well, that the HR investigator assigned to the case was actually married to one of the people on the list of suspects who were supposedly harassing Otto May. And in fact, that person had been disciplined a couple years before when Otto May had complained about a safety violation at the plant, and they did a proper investigation at that time, found the violation, and disciplined this HR administrator's husband for it. So there was no lack of bias, or at least there was certainly an appearance of bias in that situation. The other thing is to consider the job titles of the person involved. Is this a rank and file employee, or is this an agency head, a department head, a high-level supervisor? You don't want to have a low-ranking employee necessarily going after a high-ranking supervisor in an investigation, because there could be intimidation or concern, kind of the old idea, if you're going to go after the king, kill the king, because if you don't, you're going to pay for it in the end. And you don't want any of those factors influencing how an investigator proceeds. Some choices as to who you can use. HR professionals, those are the frontline folks. They're going to be the most often the ones you go to. Again, we kind of talked about the factors to consider the relationships, make sure there's no bias, there's no even any appearance of bias, and that they're appropriately investigating whoever it is. The other choice is with governmental bodies. If you have an agency or municipal attorney or a state's attorney, you could look to those. But the important thing when you're involving an attorney to keep in mind is what the role is. Are you relying on the attorney for legal advice to tell you what you should or shouldn't do, or legally can or can't do based upon the facts that are gathered? Or are you really relying on the attorney just to gather the facts? And you risk, if you have an attorney do it, one of the risks is losing the attorney-client privilege. And the attorney, because the investigator will become a witness or could become a witness and have to disclose the facts they uncovered, the attorney's in that situation too. So if you're going to rely on the attorney to provide you advice and guide you on what to do based upon the information gathered, you may actually want to have somebody else gather those facts so you can protect the privilege. The same thing, you can use an outside attorney. I've been involved recently in an investigation where we had a different outside attorney conduct the factual investigation and gather the facts, and I stayed out of the factual investigation side and just provided advice to the municipal entity based upon what was found. Again, the concern is the loss of the attorney-client privilege. In the EEOC versus Spitzer case, Spitzer was accused of sexual harassment. They did an investigation, but when it went to trial, the attorney who conducted the investigation refused to turn over his notes because he said they were attorney-client privilege. Well, that makes it hard to show that you actually conducted a proper investigation and remedied the action. The court there fined the employer $300,000 for failing to produce all the attorney's notes related to the investigation. Another choice is just an outside investigator, somebody that you know is skilled and qualified, that can conduct that shouldn't have any bias or partiality. Make sure that that's the case. And also, don't make it outcome-based. Don't say we'll pay you 10 grand if you get that guy versus just 10 grand to conduct the investigation. Some other things to consider. Do you really need a formal or just an informal investigation? That's sort of a on-the-fly decision, kind of a case-by-case. If it's really just a simple issue of insubordination or a disagreement among a couple of coworkers, you may want to just sit down with the two of them and see if you can hash it out or see if it's a much broader issue. But if it is a case that, again, triggers some area of liability, work or safety rules, discrimination, harassment, you probably want a more formal investigation in those situations. Also consider, do you need interim action? And it's not necessarily discipline, but in cases of workplace violence or threats or even sexual harassment, it's oftentimes good to separate those employees. It could be a form of paid administrative leave. You send the person accused away, say, take the week off, we're going to look at this, just to separate them so you don't have any issues of intimidation or harassment ongoing or anything of those nature. That's really an area that I'd recommend that you consult with an attorney on, because you don't want that to be construed as discipline ahead of time, particularly with regard to governmental employees who have certain rights in their job positions. We talked about at the outset, make a plan for the investigation. That's one of the key things. Know what you're investigating. Know the work area, know what policies apply, what laws apply, what applies out of the collective bargaining agreement, and know what type of evidence there may be out there. Documentary evidence, signed policies, notes passed, threatening notes, surveillance video, audio recordings if you're monitoring your phone calls with customers or with the outside just for quality assurance purposes as we hear. But know what evidence you may have that may support or may reveal what took place on any given point in time. Decide who will be interviewed. And again, the Otto May example, if the person gives you a list of people, he says, I think these are the ones harassing me, talk to those people. It may go nowhere, but talk to them. Don't blow anybody off. And make a decision of what order you want to go in. And we'll talk a little bit about this. Generally, I think you should always start with the complaining witness, and you should end or be close to the end by the time you talk to the accused, because you want to talk to everybody else and get an understanding of what evidence is out there and what the stories are before you talk to the accused. And then is there any specialized knowledge depending on the work situation? Do they need any particular technical knowledge or things of that nature to be able to assess what's going on? Preparing for the interviews, just don't go in and wing it. Just don't think, well, that's a sexual harassment case, I know what to ask. I mean, understand the lay of the land, gather your evidence, make a plan, know what questions you want to ask, know what topics you want to cover, and have an orderly fashion. You don't have to necessarily write out all your questions, but I think it is important to outline and have a plan and go in there and know what you're going to talk about. Now, this is the area when you're dealing with public sector employees, there's some things to know, some rights you have. And the primary basis for all of this is everybody's, I think, generally familiar with the constitutional provisions of due process and the notion that the government cannot deprive anybody of life, liberty, or property without due process of law. When you talk about government employees, particularly if they have just cause standards for termination, they're construed to have property rights in their position. They're not regular at-will employees. You can't just let them go for any reason or no reason at all. And so there's certain rights and protections that they have. One of those is Garrity rights. Now, this arises most often in the area of law enforcement or peace officers, corrections officers, things of those nature. But it actually applies broader. And what Garrity rights are is it's a protection, and it's based upon the notion around the Fifth Amendment that you have a right not to incriminate yourself when questioned by the government. You can't be compelled to say something bad against yourself. When you're talking about a governmental employer and they're investigating misconduct, and you say, well, I don't want to talk about that because that can incriminate myself, the employer could still order you to talk and tell you, if you don't talk, you don't answer my questions, you don't cooperate in the investigation, you're subject to termination. Well, what happens then if they say, if it's a theft case, well, yeah, I did steal that. You know, if you're going to fire me, I'll go ahead and cooperate with the investigation. And yeah, I stole it. They turn around and give your confession to the state's attorney's office and you're suddenly prosecuted. Well, Garrity is a Supreme Court case where a similar situation occurred, and what they said is if the employer compels you to make a statement under loss of your job or significant discipline, then any statement you give can't be used against you criminally, nor can any fruits of that statement be used. So if that leads to other evidence. So again, if the employer tells you, I'm going to fire you if you don't talk to me about what happened, you can invoke Garrity rights, and any statement you give can't be used against you in a criminal case. Now, that doesn't absolutely mean you can't be prosecuted, but they can't use your confession. They can't use any evidence gathered based upon your confession. It has to be independent evidence. Another thing that's in Illinois, and there's a number of other states that have it, but there's the Uniform Police Officer Disciplinary Act called UPODA, and that puts certain guidelines and limits on the ability to interrogate peace officers for misconduct. Essentially, it says that the officer is entitled to written notice of what the nature of the investigation is, who's going to be leading the investigation. There's limits on the time and the place that the investigation can be conducted. There's limitations on how long the investigation can last. You can't use abusive or offensive language in the course of the investigation or the interrogation. And there's a right to have the interrogation transcribed by a court reporter, as well as a right for the officer to have counsel there. So again, if you're, depending again on the nature of the employee you're interrogating, you need to know certain of these parameters so you're not violating their rights. Other things to consider are Weingarten rights. Those were started in the private sector, but they're by and large held to apply to public sector employees as well. Certainly most collective bargaining agreements in Illinois that I've seen build in expressly that they adopt Weingarten rights. What Weingarten rights simply are is if you're investigating and you're talking to an employee for the purposes of discipline, that there may be discipline at the end of this, you have to tell that employee this is a disciplinary interview, and that employee then has a right to have union representation with them. The last one, and this kind of goes to the whole due process and property rights issue, is Loudermill hearings. Loudermill is a Supreme Court case where a security guard for the Cleveland Public School District was terminated after it was discovered that he'd lied in his application and he had a prior criminal conviction that he didn't disclose, and he was summarily terminated. He sued saying that he had a property right and he didn't have an opportunity to address the allegations or to respond or to confront the witnesses against him. And the Supreme Court said, yeah, you're right. You're a government employee. You have a right to only be terminated for just cause. With that standard, you had property rights. You were entitled to a hearing. And thereafter, it's been by and large held that prior to termination of governmental employees, they're entitled to notice and a right and opportunity to be heard and notice of the witnesses against them. Once you conduct the interview, some of these may be fairly straightforward and common sense, but you want to try to establish a rapport with the witness, put them at ease, make sure you're conveying that no conclusion's been reached. Make sure you tell them there'll be no retaliations or actions against them because they complained or because they're participating, and that if they feel that they are being subject to retaliation, to let you know so you can address it. Be careful when you discuss confidentiality. We're going to talk about that in a little more detail later, but you cannot always maintain confidentiality. There are limits on that. It's basically the exception to the rule that you can maintain absolute confidentiality. So you need to be able to address those requests and even let the complaining witness know that you can't guarantee confidentiality in all circumstances. And get the witness to tell you about any documents or other evidence, video, surveillance, whatever it is they may be aware of, and all witnesses that they're aware of. Even if they're just a witness, they may know of other witnesses or other people that have seen something or know about it. And when you're conducting the interview, it's important to remain neutral and professional. Don't add commentary, well, oh, I can't believe that SOB did that, or that's horrible, I can't believe that, we're going to get this guy. You want to stay neutral, again, impartial, objective. It's okay to show empathy, saying, I'm sorry to hear that, we're going to investigate this, we're going to figure it out. Do you need a moment to compose yourself? Those kind of things are okay, but don't look like you're taking sides in the course of it. When you start, generally I prefer to start with open-ended questions because you're not prejudging this. You want the witness to tell you what happened and then phrase your questions later on. You can get more specific if you're trying to get to the heart of the matter, but you want their story. You don't want your understanding of the events. The other thing is explore bias. Ask the witness what they think of the accuser and what they think of the accused, just to see if they've got a dog in the fight, if they're friends with one side or the other, so you can kind of put their perspective into the mix and understand if they have any bias or reason to fabricate their story. Conducting the interview, take notes, take a lot of notes. I think this is a key factor, particularly because you may be a witness. Plus, there could be significant decisions made based upon what you do. In certain situations, and I try to do this, depending again on the significance of the investigation of the misconduct at issue and who I'm interviewing, but oftentimes with the accused, I will have another person in the room with me and I'll have that person take notes while I actually interview or interrogate the accused. I often do that with the complaining witness as well, just because if I'm taking notes, I kind of lose the thought at times as I'm looking up. But the other thing is I like to keep my eyes on the witness and look at their demeanor, look at how they're reacting. Are they looking at me in the eye? Are there other subtle signs that they're nervous or they're hiding something? I think that's important. The EEOC itself has listed a number of factors to be used in assessing the credibility of the witness. You know, we talked about one of those a minute ago, demeanor. Is the witness nervous, argumentative? Do they look like they're truthful? Do they look like they're calm? Motive, do they have a reason to lie? You want to explore that. Is their story plausible? Does it make sense? I mean, you can think in generally, you know, you hear stories now and then like people don't act like that. I mean, that just seems odd. And so you want to take that into factor too. Supportable. Pete talked earlier about the fact that judges and juries often believe paper over people. If there's additional documents that support the story or video or things of that nature. And then look at the prior record of the witness too. Do they have a disciplinary history? Do you know they've been in trouble before? Things of that nature. The other thing is, you know, I would note credibility of the witness separately, and that's my preference. Another thing is I always interview one witness at a time because if you don't, you get, even if they're relatively minor witnesses, you put 2, 3, 4 of them in a room and say, we want to talk about this. You tend to get the strong personality to take control, and they answer all the questions, and the quieter ones or the weaker ones may not speak up. They may not offer their input, and you may miss something. As far as, you know, this slide talks about preparing statements for the witness to sign. I don't always do that. I'll do that if I have a concern that the witness may be feeling intimidated or may be coerced into changing their story, and I'm trying to pin something down. After the interview, I'll type up a quick summary, either in an affidavit form or just notes that they can sign. Let them and make clear, and if I email that to them, which I've done in the past, I'll put in the email, if anything's incorrect or you disagree with anything, please make changes, let me know. But if this is an accurate statement, please sign it and give it to me so you have a record of it. You know, some people I know I've talked to have actually just made notes on paper afterwards. I'm not a big fan of that, but if that's the best you can do, then do it. I would make sure if you're signing the notes or even if you're preparing an affidavit, don't put in your credibility determinations. Don't put in there they look shifty, they look dishonest or anything like that. Just put the facts. You know, the old dragnet, I'm probably dating myself, but just the facts, ma'am. When you interview the complainant, again, you want to assure the complaining witness of the impartiality. You want to talk about confidentiality, which we're going to get to here shortly. But again, make sure you're not promising absolute confidentiality. Again, if you're going to base an employment action, you're going to terminate or suspend somebody or discipline somebody on this, they're going to have a right to know why and what it is. So you can't assure confidentiality. And oftentimes I'll ask the complaining witness, what do you want to see out of this? What outcome do you want? Make it clear when you do that ultimately it's the employer's decision as to what's going to happen. But I think it's helpful at times and it can kind of gauge how serious the complainant feels about it or what their view is by just asking them, what do you want to see come out of this? And again, the same thing we talked about before, don't take sides, don't argue, don't bicker, just get the statements from them. Interviewing the accused. As I talked about before, I prefer to save the accused for last after I've talked to most of the other witnesses. It doesn't always happen, and there's been situations where I've had a few witnesses, minor witnesses left, but I have a pretty good sense of what the story is or what everybody's story is, what the documents are by the time I talk to the accused. And I'll explain the process to the accused and tell them, look, we need your side of the story. We need what evidence you have. Here's what we're investigating. But again, I don't get too specific on all of the details because you want their version. So, you know, so-and-so says you harassed them. So-and-so says you stole property. So-and-so says you did a drug deal on the back lot. You know, and give them just the general nature and then let them fill in the details of why they were at a particular place or what was said or who was there. You can get more specific as you're testing their story. But again, leave it pretty open. Keep in mind the rights we talked about, Garrity rights, UPOTA if you're dealing with a police officer, Weingarten rights, things of that nature when you're doing it. If they're saying that, you know, I never did that and so-and-so's just out to get me, well, ask them, why would they lie? What's the issue? Why would they have an axe to grind against you? Why are they picking on you? and explore that issue as well. And then make clear to the accused, and I always do this, you are not to interfere with my investigation. You're not to go try to talk to the witnesses. You're not to try to intimidate them. You're not to retaliate against the person who made the accusations. And I had an investigation where the accused was a department head, and sure enough, after I told witnesses, and I told all the witnesses, if you're interfered with or you feel intimidated, you let me know. And I met with the accused, and the day after I met with the accused and interviewed him, I get a call from one of the witnesses that he's putting pressure on me. And he wants me to sign an affidavit to say exactly the opposite of what this person had told me. I can tell you that goes to a credibility factor. After I've told the accused, let the process work, and he's out there trying to change the stories. Other considerations in the interview: do you record the interview? Again, in UPOTA, you're supposed to have a court reporter present, make a transcript, so in those situations that decision's made for you. But do you make an audio or a digital recording of the interview? Well, keep in mind the Illinois Eavesdropping Act. You have to have the consent of all parties to a conversation. It's based upon the notion of the expectation of privacy. If you are going to record, you better let the witness know, and you better get the witness's consent to the recording, lest you be violating Illinois law and subject to civil and even criminal penalties. Do you review emails and text messages? This is another difficult area. And basically, there's federal as well as state law. The Eavesdropping Act in Illinois limits your ability to retrieve electronic communications, as does the federal statute, the Electronic Communication Privacy Act and the Stored Communication Act. Limits when you can go after these types of electronic messages. You basically have to have consent, and you're not going to always get consent at the time of the investigation, but you could have implied consent. And the way you have implied consent, if you're an employer, have a policy on that. Say, any text messages you send on a company phone will be monitored. Any emails you send on the company network or the employer network or the county network or the city network will be monitored. Now, it doesn't mean you have to actually monitor them all times, but you better be clear that you will monitor. And I had a case where the policy just said the employer may monitor the emails. And this was a private case where you had three people open a business together, and then they got a sense that one of the individuals was out going to go start his own business, was sending emails to himself with customer contracts, pricing information, other confidential information of the business. So they went into his email and they went onto his BlackBerry text messages onto their BlackBerry server, and they found out, aha, he really was doing that. And for their efforts, they got sued for violating the Electronic Communication Privacy Act. And so now you just gave the employee, the bad actor, a cause of action against you. And that was a case, as I said, the employer's policy said, we may monitor your emails. And the court there said, may isn't strong enough because may isn't will, and it doesn't tell them that they have no expectation. It just, it's vague as to where their expectation of privacy lies. So again, if you're going to go into emails or text messages or electronic communications, it's an area I think you should consult with attorneys about. Can you require confidentiality? We talked about that we'd get to this. First and foremost, with governmental employees and the due process rights and the fact that if you're going to take significant disciplinary action against them, they have a right to notice, they have a right to respond, so they have a right to know of who's accusing against them. That's one reason that it's virtually impossible to maintain confidentiality. The other reason is the National Labor Relations Board, based upon Section 7 of the National Labor Relations Act, says you cannot have blanket confidentiality. And Section 7 of the National Labor Relations Act gives employees the right to engage in concerted activity for mutual aid and protection. And what it's construed as is concerted activity is the right of employees to talk to each other about wages, hours, and working conditions. And if you're investigating misconduct, that's a working condition. They're entitled to talk about that for their own aid and protection. And so the NLRB frowns upon blanket confidentiality of telling employees they cannot discuss it. The EEOC also discourages blanket confidentiality. They don't want any employee to feel that they can't come to the governmental agency and complain about harassment. And again, if you're telling your employees that if you make a complaint of harassment and we investigate, you can't talk to anybody else. The EEOC takes the view that you're telling them they can't report that to the government, and they don't allow that, and they've gone after employers for blanket confidentiality policies as well. There are exceptions, and again, I mentioned before, there's an exception to the rule. If the witness is in need of protection, if they're in danger physically or they're in danger of coercion or harassment, that may warrant it. If there's a risk that evidence could be destroyed, that may justify a certain level of confidentiality. Same with if they're going to get somebody to fabricate testimony, you could do that. But if you're going to invoke any form of confidentiality, you better document the reasons why, what your beliefs are, in order to justify it. Otherwise, again, you can limit disclosure, and you don't want to be feeding the rumor mill at work and telling all employees. You only want to be talking to those who would have a reason to know. But again, you can't enforce blanket confidentiality. As you're nearing the end of the investigation, it's kind of good always to do a double check. Make sure you're being impartial. Is it too one-sided? Are you only looking at one side story? Are you not looking at all of the witnesses' statements and all of the versions and events? Have you interviewed everybody? Again, the Otto May case where they didn't interview anybody. Have you interviewed the key witnesses that the complainant talked about? Did you review the documents and go back again and compare the documents to the testimony and see if there's any inconsistency, any confusion, and that'll tell you if you need any follow-up. And it's always a good time during your review to talk to an attorney for legal advice as to what somebody's rights are or what you can or can't do in the course of the investigation. Once you've completed it, it's important to prepare a report. And again, the fact finder who does the investigation isn't the decision maker, and there shouldn't be necessarily in the report decisions of we're going to do this, we're going to suspend, or I recommend suspension or discharge or whatever it is. The report is just to say what was being investigated, give a timeline and a history of the investigation, and set forth the facts that you've concluded are true or that you found evidence to support of. If you haven't been able to resolve a factual issue, note that and why you couldn't resolve it. It could be something like the security camera catches who goes into the hall but doesn't show who gets to the employee's workstation. And during the time that the note was left, we could see 12 people went down that hallway, but we don't know what they did after they got out of the camera view. So we don't know who left it, or we don't know precisely the circumstances of how the note got to be at that workstation, something like that. But again, answer the factual questions you can, give support for it, and make note of the ones you can't. And then also in the report, just identify that you'll be turning this report over to whoever the key decision makers, the managers, the HR folks who will make a decision. And then there should be a meeting even with the fact finders and the decision makers where the decision makers can ask questions, they can review the report, what happened here, what happened there, what did this witness say. And ultimately the question you want to answer is, were laws violated, were policies violated, did misconduct occur? If you answer those in affirmative, then you got to make a decision on what's the appropriate level of discipline or what's the way to resolve it. But it's always very important, make a conclusion. Don't leave it hanging. Don't leave it up in the air. If you determine that harassment or discrimination occurred, by law, the employer has to remedy the situation. So you've got to take steps there. And it could be something just by transferring the accused, demoting, loss of bonus, counseling, training, but it could be up to suspension, discharge, things of that nature. Again, it depends on the facts and the circumstances, but you have to do something to address discrimination, to show you've done something to stop the offensive conduct, and also send a message that it won't be tolerated in the future. There are things you can do with the complaining witness as well if harassment or discrimination. Certain situations, you may want to offer them some paid leave just to kind of get over it, paid counseling. If they actually incurred any actual losses, the Otto May case, his tires were slashed, if you want to compensate for that, those are things you can consider. If you are looking at making a monetary payment to the employee, I would advise that you try to get a release of claims with that. if you're going more formal along those lines. And at times you can make an offer to transfer the victim or the person who complained of harassment, but be very careful when you do that. You don't want that to come across as retaliation for the fact that the witness complained or they said that they were subject to mistreatment. Only transfer them if they ask or they're willing to do it. Don't force a transfer on them because you could be accused of basically retaliation from them making the complaint. And once the investigation's complete, you've made a decision and you're moving forward, it's important to meet with the complaining witness. You don't have to give them the actual report. You don't have to go through everything, but you should give them enough information on what the investigation found, what the conclusion was, what the action is. I typically then would have a memo prepared to be put in the personnel file that on this day we met with the complainant, we reviewed the results of the investigation, here's what was discussed, and just document it in that way. And you can ask them, if they're upset or they have any concerns over what happened, and let them have their chance to speak on that as well. Follow up with the accused as well. Same sort of thing, meet with them, tell them what you found. Now, again, if there's going to be discipline, there's Weingarten rights that come out of that. You can't just meet with them alone. They have a right to representation. If it's going to be a discharge, a suspension, they'll have Loudermill hearing rights, so they'll have a notice and opportunity to be heard. So it's not as simple as how you meet with the accused, but you should be meeting with the accused and letting them know their findings as well. And lastly, this is just kind of the list of things to keep in mind, the common failures and mistakes to avoid: failing to plan, ignoring complaints or problems, overlooking them, doing nothing, delaying the investigation. And delaying the investigation is a problem as well. I'll give another quick story. I'm aware of an arbitration case where an employee was terminated after being accused of using the term monkey in a racially derogatory way to another employee. The employee made the complaint of the statement. It was more than 8 weeks before the employer took action on that, even interviewed, and then they only interviewed the complainant and the accused, and then terminated the accused. And the employee was a union employee. They grieved that discharge. And the labor arbitrator said, well, if it was such a serious allegation to you, why did you take 8 weeks? Why did you only interview 2 people? Why didn't you get more background, more history on that? So the actions of the employer and how they handled that issue came back to hurt them. And the labor arbitrators often find that discharge, they call it the capital punishment of labor law, and they're hesitant to uphold discharges. And in that situation, they said, hey, the actions of the employer and the investigation and the delay cut against the seriousness of the offense and cut against the seriousness of it warranting a discharge, and they reinstated the employee. So again, just kind of keep those factors in mind and we'll move on.